Hello everyone, welcome back to our channel. This video is going to be about CA Final, Self-Paced Foreign Modules, Set A, Corporate and Economic Laws. In that too, Company Law, we are going to see about the Directors chapter. And whatever the notes I'm using here on the screen, it will be available in the website. The link for the website will be there in the description and in the pinned comment. You can log in into the website and download the notes for free. Now I will tell you how to use the website to download the notes. Now here in the browser you can type Mission CA Virtuals and then you can see the first page which is opened and here you can click on it. Now here if you see, you will see this tab CA Final SPOM free resources. When you go into that, you will be able to find all the SPOM resources. Set A, Set B, Set C, Set D, everything will be there. Instead of scrolling through Telegram channel, word messages and all, you can just come here and then find these resources. Just you have to log in into the website, then you can access the resources for free. So all the YouTube channel links, YouTube videos links, and then the resources PDF, everything will be uploaded here. Inside the Set A folder, it will be available. So you can easily come into this website, log in with your mobile number, and then view the PDF resources. So now we can start the chapter. Now we can start to see the overview of the topics in the chapter Appointment and Qualification of Directors. This is the first chapter in company law. Now we can start the chapter. Here the first thing which we are going to see is every company should have board of directors and that is compulsory, and we have only individuals as directors. We cannot have company or organizations as directors. And in the case of minimum number of directors, based on the type of company, for public company we have minimum 3 directors, private company 2 directors, one person company 1 director will be minimum number of directors. The maximum number is 15, but if you want to increase this, you can appoint more directors by passing a special resolution. Special resolution should be passed in order to appoint more than this number of directors. Next, woman director. At least one woman director should be in the board of a listed company and other public companies. The other public companies which satisfy this condition, the paid up share capital should be 100 crore or more, turnover should be 300 crore or more. If this limit is satisfied, then the other public companies should also appoint a woman director. Next, we are going to see the complaints by a newly incorporated company. If we have a newly incorporated company, they have to comply with this provision within 6 months from incorporation. If there is a vacancy in the place of a woman director, we have to appoint it, we have to fulfill it in within next board meeting or 3 months, whichever is later. This limit you have to note here, and then the important points also you have to highlight here. Next, resident director. Every company should have one resident director minimum. That resident director should be staying in India for a period of 182 days during the financial year, during the current financial year. Next, independent director. We have a separate provision for independent director, which we will be seeing later. So now I am skipping it. Next, interested director. For example, we have a director who is interested in a transaction. What is the meaning of interested in a transaction? For example, he is having an interest in the share capital, or he is a related party to the transaction. Like that, he is having some kind of interest in the transaction. Because of the transaction, some kind of benefit is going to the interested director. So, such interested director should disclose his interest. We have separate sections for that. And then executive and non-executive directors. We have two types of ones, executive and non-executive. Executive directors are the directors who do all the work in the company. They will be the ones who will be implementing all the things in the company, like new projects, and they will be bringing up new projects. They will be supervising the sales, marketing, everything. All the thing will be done by them. But non-executive directors, they will be in the top management of the company. Both executive and non-executive directors, both of them will be in the board of directors. These non-executive directors, they will be in the board, and then they will frame the policy decisions of the company. They will frame the long-term policy of the company. Like that, all the expert decisions will be taken by the non-executive directors for the future of the company. And these non-executive directors, they will be persons who are expert in their particular fields. We will take them and we will be appointing them in the board. They will be providing us insights related to the policy of the company. This will be done by the non-executive directors. And independent directors, they are a type of the non-executive directors. This is one more fact that you should be aware of. Next, appointment of directors. We have two types of directors. One is the first directors, and then the second one is the subsequent directors. The first directors, they will be the subscribers to the memorandum. Normally, articles of association will mention the name of the first directors. If that is not, then we will be considering the subscribers to the memorandum as the first directors. In case of one person company, that particular individual who is the member, he will be the first director. Subsequent directors, normally they will be appointed by the shareholders in the general meeting. And then additional director or alternate director, these are some special kind of directors. They will be appointed by the board of directors. The power to appoint these kind of special directors will be given in the articles of association or by a special resolution or by the Companies Act to the persons who are appointing. That is the board of directors. This power given by this manner to the board of directors to appoint these special directors. Next, other requirement of appointment. If a person should become a director, he should have director identification number. Next point, he should furnish that in to the company. He should send it to the company, and he should also give a declaration that he is not disqualified to be appointed as a director under section number 164, which we all know that it is about the disqualification of persons who are going to be appointed as a director or disqualification of director. And then the person who's going to be appointed as a director, he should give us a written consent that he willingly is going to be appointed as a director. His written consent must be there, and that consent should also be filed with the registrar by the company. And explanatory statement. If the director being appointed as an independent director, he should fulfill the extra conditions also, which we will be seeing later. We have some exemptions also here, which you can read it by yourself. The next point is retirement of directors by rotation. Here, every year we have to make some directors go to retirement. We have to retire some directors by rotation because we don't want same set of directors who are ruling the company for their entire lifetimes. So here we have two cases. First case is that if the articles of association of the company provides that all the directors will retire in the every general meeting. In every annual general meeting, all the directors will retire and we can appoint new directors. How the new directors will be appointed? The shareholders will pass resolutions and they will appoint the new directors. This will be happening in the general meeting, annual general meeting that we are talking about here. The second case is that if the articles of association is not telling you that all the directors will retire, then what will happen? We have to apply the provision of retirement by rotation in the Companies Act. Now we will be seeing how this provision will be given in the Companies Act. In this Companies Act, they have given that not less than 2/3 of total number of directors of a public company. This provision is applicable only to public company. Here they are saying we have something called as total number of directors. We will take a number called total number of directors. We will see later how this number will be arrived, and then out of this number you should multiply by 2/3 and then not less than 2/3. So whatever the number you are getting, for example 4.3 or 4.5 or 4.67, whatever the number you are getting, you should always round it off to upper number. You should round it off to 5. 4.3 also will be rounded off to 5 only. This is a very important matter which you should know. Total number of directors should some number you will get. Out of that, 2/3 you should multiply, and then that resulting number should be upper round of always. This is the first point. Next, such number of result which you are getting, total number of directors multiplied by 2/3, you are getting some fractional number or some whole number, and this number you should upper round off. After that, you will get a final number. This number of directors will be liable to be retirement by rotation, to be selected by retirement by rotation. They are liable to be retirement by rotation. The next point is the number of directors who are liable to retire by rotation. Out of that, 1/3 directors will actually retire. Now for this we can see an example, and one more point which we need to know is that in total number of directors we have some directors who will not be included. For example, the total number of directors you are having, out of that independent director will not be included, and then the nominee director will not be included. These two will not be included in the total number of directors. This provision also is given here. You can read it, and then you have to highlight the important points also. First, we can see an example here. For example, we are having a company which has 12 directors, 2 independent directors out of the 12, and then 1 director is nominee director out of the 12. Now, the total number of directors we have to take 12 minus 2 independent directors minus 1 nominee director. 12 minus 3, 9 directors will be the total number of directors for the purpose of applying this provision of retirement by rotation. And then out of this 9 directors, 9 into 2/3, this will be 6. 6 directors will be liable to retire by rotation, and then out of the 6 directors, again 1/3, 2 directors will actually retire by rotation. Now you may have a doubt. If you get a fraction here, the liable to retire by rotation, and then you are multiplying 1/3. Here, if you are getting a fractional number, what you will do? This will be normally rounded off. This you should round off to the nearest number. So this is the normal rounding off. Normal rounding off will be done when you are multiplying the 1/3. Now, once we find out how many directors should actually retire, now we have to decide who will be the one retiring. Here, who's the one longest in the office, that person will retire from the director position. If 2 persons are in the same time limit, the 2 of the persons were the very old persons who were longest in the office and they were appointed on the same day, we will decide between them based on mutual agreement or by lot. After retiring, we will appoint new directors in the general meeting in their place. If we are having a vacancy, it will be filled by appointing the same retiring director, or we can appoint any other person also. In any case, the number of directors should not go below the minimum directors required for each type of company. And then if the general meeting is not held, we can the retirement cannot be postponed. They will retire as and when on the date of the general meeting. The directors will retire on the last due date of the general meeting, even if it is not held. Next thing is deemed reappointment of retiring directors in some cases. Now, if the vacancy of the retiring director, we are not making any resolution that we are appointing the retiring director itself, or we are not expressly resolving that we will not fill the vacancy, that also we are not doing, and then the meeting is completed. Now, what will happen? We did not make any resolution regarding the retiring director and the position of the retiring director. So, the meeting will be adjourned. It will be adjourned to the same day, next week, same time, or same place. If it is a national holiday, next day, which is not a national holiday, will be the meeting will be adjourned for that date. If the adjourned meeting, in that adjourned meeting also we are not filling up the vacancy, then the retiring director will be considered to be reappointed with immediate effect. But in some cases it will not be possible. We have put up a resolution for the reappointment of the retiring director, and we did not pass the resolution. The resolution lost, and then he gave his unwillingness to be appointed as a director in a notice. He is disqualified. Some resolution we have to pass to appoint the director, and in some cases that deemed reappointment will not happen. That cases have been listed here. You have to read this and then highlight the important points. Some exemptions are also given. You can read it by yourself. Next is the provision relating to the director identification number. As we saw already, we need to have director identification number for every person who is going to be appointed as a director. We should make an application to the central government, and then we should obtain the DIN. DIN includes the DPIN also, designated partner identification number for LLP. That will also be included under DIN. Now, everyone should have DIN. We have to make application to central government, as we already saw. We are going to see the process of obtaining DIN in a very short manner. First, you have to fill the form, pay the fees, and then apply to the central government. You will get an application number. CG will process the application, central government, and then within 1 month, you will be communicated about the approval or rejection of your application. If you are approved, your DIN will be allotted, and you will get it through electronically or by post. You will be communicated that DIN in any manner. Next, if the application is incomplete or defective, central government will intimate through email. You will get an email, and then you will get a time to rectify the defect. Within 15 days, you have to rectify. And then, if you rectified the defect, but that rectification is also not correct, you are not properly giving the rectification also. So, in that case, central government will reject your application, and then you will get an instruction to file a fresh application. And if you did not even bother to rectify the defect, then your application will be treated as invalid. And then, in that case, also, you have to make a fresh application. In these two cases, you will not be given any refund of the application fees which you paid earlier. So this is the short form of the process for obtaining DIN. You cannot obtain more than one DIN. There is a prohibition on that. The director, once he gets the DIN number, he should tell it to the company. He should intimate it to the company within 1 month. The company will update with the registrar within 15 days. We have some punishment also, and then wherever the documents of the company, the director's reference is mentioned, or in such other documents, we have to mention the DIN mandatorily. We have punishment for section 152, 155, 156. You can read that. And then we can cancel the DIN number, surrender the DIN number, deactivate the DIN number, reactivate the DIN number. The cases for that are also given. Duplication, you are obtaining with a wrongful manner, death of the person, declared as unsound mind, insolvent, you are making an application to surrender, and then you are not intimating your particulars in this form within the stipulated time. KYC you are not doing. And then if you want to reactivate such deactivated DIN, you have to file this form. After that only it can happen. If there is any change in the particulars of the DIN application, any change in the situation, you have to update it to the government within 30 days. That application should be accompanied by a certification by a chartered accountant or a company secretary or a cost accountant in practice. It shall be in this form. And then the electronic database will be updated. The DIN cell will intimate to the concerned registrar. The DIN particulars change should be intimated by the director to the company within 15 days also. You should tell to the company also relating to this change. So that's all about the provision of DIN. Now we can see the provision of small shareholder director. What is the meaning of small shareholder? If you are a shareholder holding shares up to face value of 20,000, then you are a small shareholder. If you are a small shareholder, you can gather many small shareholders, and then you can go to the company, make an application, elect a director for you. You can have a small shareholder director in the board of directors of the company who will represent the interest of the small shareholder. So how many small shareholders we have to gather to appoint a director? Minimum 1,000 shareholder or 1/10 of the total number of small shareholders, whichever is lower. This number you have to find out first, two numbers, and then you have to take the lower. That lower number, that much number of small shareholder, you have to combine, you have to gather. After that, you can go and make an application to the company to appoint a small shareholder director. In case of a listed company, the company on its own, it may appoint a small shareholder director also. If you are making an application by gathering small shareholders, you have to give notice to the company 14 days before the meeting. And then if you are proposing a person who is also a small shareholder as a small shareholder director, now what you have to do, you have to give the details of such person, name, address, how many shares he is having, the number of those shares, folio number, that all you have to tell. you have to give a notice also that mentioning his director identification number, he is not disqualified to become a director, his consent to become a director. The next point is whether small shareholder director is an independent director or not. If he satisfies the condition, he is an independent director. If he does not satisfy the condition, he is not an independent director. That's all. Then he will not be liable to be retired by rotation. So, in total number of directors, we saw that independent director will not come, nominee director will not come. Now, another point: small shareholder director will also not come. This is the another provision which you can understand by this statement that small shareholder director cannot be liable to retire by rotation. Next, the tenure term of the small shareholder director will be maximum 3 continuous years. After that expiry of the tenure, you cannot reappoint the same person. And then if a person is not eligible under section 164, he is disqualified, then he cannot be appointed. If the small shareholder director gets appointed and he gets some of the disqualifications, or his office becomes vacated in section 167, or he does not meet the criteria of independence, then also the small shareholder director's office will be vacated. Like that, it is given here. Maximum number of directorship. A small shareholder director cannot be a small shareholder director in more than 2 companies at the same time. Maximum 2 companies is allowed where he can work as a small shareholder director. Both the companies should be in the different business. They should not be in the competing business or conflicting business. Simply, they both companies should not be competitors to each other. And then cooling period. After appointing a small shareholder director, completing his tenure of 3 years, after that we have to give again 3 years cooling period. In that cooling period, he should not be associated with the company directly or indirectly in any manner. Next, we are going to see some special kind of directors: additional director, alternate director, director for casual vacancy filling, and the nominee director. This director will not be appointed by the shareholders in the general meeting. Sometimes board of directors will appoint, sometimes some other financial institution will appoint. We will see that in detail. Additional director. This type of additional director is appointed to meet the urgent need for working requirement. We want more directors to work, but we cannot wait for the general meeting to appoint them. We can appoint them for urgent need. This power we are getting from the articles of association for the company. If the articles does not give you that power, you cannot do that appointment. And then the term of such additional director will be date of next AGM or last date of AGM, earlier or above. The earlier date will be the maximum term for which the additional director will be holding the office. If a person is rejected by the shareholders, then that person we cannot appoint as an additional director. Next, the term of office, that also we saw. And then he is not a retiring director. If you want to make him a regular director, till now he is just an additional director. He does not have that much power and all. He will vacate when his term is completed. If you want to make him as a regular director, you have to follow the normal procedure. Next thing is alternative director. If one of the directors of the board goes out of India, he is absent from India for a period of 3 months or more, then you have to appoint an alternate director in his place. This alternate director will be appointed by the board of directors and not the original director who is leaving the country. So next, who we can appoint? We can appoint any person, but he should not be a director already in the same company. He should not be an already alternative director for any other director in the same company. So in the same company, he should not be a director, not be an alternative director. Then such person we can appoint. If the original director returns to India, then the alternative director shall vacate the office. The next point is the power to appoint the alternative director comes from the articles or a special or a resolution passed at the general meeting. Not necessarily special resolution, but any resolution passed in the general meeting. So this power is given by articles or resolution. This is not given by the Companies Act. This is one more thing which you have to remember. Next, if you are considering the number of directorship for maximum number of directorship, then this alternative directorship will also be counted. Next, you have to obtain the consent of that such particular person you are going to appoint as alternative director. You have to file the consent with the registrar. The term of office also we already saw. And then if the term of original director is expiring and he still did not return to India, then the alternative director term of office will also expire. So this is the provision relating to the alternative director. Here we have an example also which you can read by yourself. These important points you have to mark down, and then you can write some important points also in the form of notes here. For example, consent should be filed. You can write it like that. This will help you to recall the important points quickly during your IBS exam. 4-hour exam, when you are turning the pages, you will get to know the important points very easily. Next, nominee director. For example, you are taking a loan from a bank. For example, you are taking a 100 crore loan. This is a very big amount, and then the bank has to ensure that you are following the loan requirements properly. Your business has the capacity to repay the loan. You are using the loan for the stated objectives only. For those reasons, the bank will appoint a director in your board of directors. that director will be nominated by the bank. He will make sure that the interest of the bank is protected at all times. So that such a director is called as nominee director. You cannot retire by rotation. This you cannot make this director to retire by rotation. This is one important point. If you are a government company, the central government or state government also can appoint a nominee director. This is the meaning of nominee director. And then this is a special type of director which is not appointed by the shareholders. Next is casual vacancy. If we have a director who is appointed at the general meeting, we already saw that normally directors will be appointed by the shareholders in the general meeting. Such a director, his term of office does not expire in the normal course. So time is still pending. He has still time. He can be the term of office of such director is still not expired. He still has the time to work as a director, but due to some reason, his office gets vacated. So in that case, we can appoint another person in the place of the original director till the term of the original director for the casual vacancy fulfilling. We can appoint an extra director to fill the casual vacancy in the board meeting by a meeting of the board. Next, the director which we are appointing to fulfill the place of casual vacancy, that director will be holding office till the date of original director who was replaced, who was vacated, and in that place we got the casual vacancy director. So this is due to sudden happening and not due to the expiry of the term. If the director is vacating the office due to expiry of the term, then that will not be a case of casual vacancy. For filling casual vacancy, the power is coming from the Companies Act, and Articles of Association need not give the exact power to the Board of Directors. This power is given by the Companies Act. Next, if the casual vacancy, you have an original director who is appointed at the general meeting, and then he has vacated his office due to some other occurrence. You are appointing a casual vacancy director. Now this casual vacancy director also vacated due to some casual occurrence. Then in that place you cannot appoint a casual vacancy director. If you want to appoint a casual vacancy director, the original director should be appointed at the general meeting. This is one of the conditions to appoint a casual vacancy director. What is the meaning of casual occurrence? How the office will be vacated? For example, the original director gets a disqualification, or he is giving a resignation, or he is being removed. In such cases, it will be considered as a casual vacancy, and the power will be given to the board of directors to appoint anyone. If the board of directors consider that we can manage the company even without appointing anyone, they may also make a resolution in the board meeting that we will not appoint anyone in the place of casual vacancy. That also they can do. So this is the point of casual vacancy, additional director, alternative director, and nominee director. Next, we are going to see about the section 164, disqualification for director. For example, if he is unsound mind, insolvent, or adjudicated as an insolvent, or his application is pending, he is convicted by a court, imprisonment for not less than 6 months, minimum 6 months imprisonment, and 5 years schooling period has not passed. Like that, if you are falling into some situations in this list, you will not be eligible to be appointed as a director. You will be disqualified. The next thing is you are working in a company. That company did not file the financial statement or the annual return for a continuous 3 financial year. Now what will happen? All the director in such company will be considered as disqualified. If you are appointing any new director in that disqualified company, in that wrong company, you are appointing a new director. That director will be given 6 months time to rectify all these defects. Even after 6 months, these defects are not rectified, then that new director will also be considered to be disqualified. Some exemptions here, you can read that. Additional qualification by a private company. If you are going to become a director of a private company, such private company in their articles of association, they may mention such other conditions also which you should satisfy. Like for example, graduate only we can appoint as a director. If you are going to be appointed, you need this much amount of shares, you have to hold it. So this kind of additional qualifications may be imposed by the articles of association of a private company also. Disqualification, if you are getting under section 217, like inspection, inquiry, investigation, you will be learning that section. If you are getting a disqualification under that section also, your office shall be deemed to be vacated. We will be seeing other cases also in which our office will be vacated in some other section. Now the next thing is we have to see the maximum number of directorship. If you are going to become a director, the maximum number of directorship is you can be a director in maximum 20 companies at the same time. Maximum 20 companies only allowed. In that also, public companies can be only 10. In this public company, the meaning of public company will come, or other private company which are a holding or subsidiary of a public company. That will come under the public company meaning for this particular purpose of finding out the maximum number of directorship. So other information also given, you can read it here. And then independent director. Now who's an independent director? We will be appointing independent director in our board of directors. They will be a non-executive director, and then they will be expert. They will see the situation of the company, and they will make sure that the company is not going into the wrong hands, or the company is going in the right direction. That and all will be ensured by the independent directors. They will safeguard the interest of the minority shareholder and then the small shareholder. Like that, they will act in an impartial manner and then they will ensure that the company is going right. For listed companies, minimum one-third of your total number of directors should be independent directors. If you are other public company, you are satisfying this limit, you will also be mandatorily having minimum 2 directors as independent directors. This limit you can note it down here. You have to compulsorily note it down, and then these important points also you can highlight. You have to highlight. The next point is under Companies Act, we have to appoint an audit committee for certain companies. In that audit committee, minimum 3 directors should be there, and then in that majority should be independent directors. Due to that requirement, if you are getting a consequence of appointing more independent directors, you have to appoint such other extra number of independent directors also as may be required. If there is any intermittent vacancy for an independent director, you have to resolve it in next board meeting or 3 months, whichever is later. Within this time limit, you have to fulfill the vacancy. Next, if a company does not fulfill these conditions, you are not a listed company, you are other public company, you are not fulfilling these conditions for 3 consecutive financial years, then you are exempted from appointing an independent director. You need not appoint an independent director. Next, the thing you have to see, this paid up share capital, turnover, outstanding borrowing, this you can see in the last date of latest audited financial statement. You can see. If you are an unlisted public company and you are a joint venture, wholly owned subsidiary or dormant company, you need not appoint independent director. This also you can see. Now the next thing is independent director will not be a managing director, will not be a whole-time director. He cannot be a nominee director. He should have integrity, expertise, experience, and then he should be independent. He should not be a promoter of company, associate, subsidiary, holding, cash. He should not be related to promoter or director of cash. He should not have any pecuniary relationship. What is the meaning of pecuniary relationship? You are having some significant monetary relationship with the company, which is the monetary relationship which you are having with the company is a transaction which is more than 10% of the total income. Then you are not eligible. But up to 10% of total income, then it is okay. Total income of the individual, the person who is going to be appointed as an independent director. This limit you have to follow during the 2 immediately preceding financial year and also during the current financial year. So you should follow this limit. Within 10% of your total income, you can do the transaction, have the monetary relationship, but more than 10% is not allowed. And then if you are making any transaction in which you are treated on par with any general public, if any general public is buying the product, then also that is the price. If you are buying the product, then also the same price only you are paying. If you are doing it arm's length price, then in that case it will not be counted as a pecuniary relationship. And then the receipt of remuneration as a sitting fees. Under section 197, you will be having a concept of sitting fees. You will be giving the directors fees for attending the board meetings. That will not be counted under pecuniary relationship. If you are getting any reimbursement of expenses or any profit related commission which is approved by the shareholders, then also that will not be considered under pecuniary relationship. Your relatives should not hold any securities in the cash in immediately preceding 2 financial year and current financial year. But we have an exception. Relative holding a security in the company up to 50 lakh face value he can hold, or 2% of paid up share capital of cash. This he can hold. That is allowed for the relative, not for the independent director, but for the relative. If the relative is getting any loan from the company more than 50 lakh in the immediately 2 preceding financial year and the current financial year, then you are not allowed to be an independent director. Your relative should not get loan from the company. And then your relative should not have given guarantee of security to cash or its promoters or its directors during the immediately preceding 2 financial year and current financial year. The limit is 50 lakh or more is not allowed. So less than 50 lakh you can give. 50 lakh or more is not allowed, guarantee or security. Next thing is you are having any other pecuniary relationship which is more than 2% or more of the gross turnover or total income, then such other pecuniary relations you are having, so you during that thing also you will not be appointed as an independent director. Transaction up to 10% of total income is allowed for the independent director, and then more than that is not allowed with cash, director or promoter. But here the relative should not have pecuniary relationship with the company, subsidiary, associate holding for 2% or more of the gross turnover or total income. This limit is for the relative. Now, neither himself nor his relative, both of them, they should not be a KMP or an employee of company, associate, subsidiary holding in immediately preceding 3 financial year. But one exception we are having, relative can be an employee during the preceding 3 financial year. This restriction will not apply for a relative who is an employee. Relative, not KMP. That is not allowed, but relative employee is allowed. Next, if you are a proprietor, employee or partner of the cost auditor firm, company secretary or auditor firm who has provided the services to this company, then also you are not allowed. Not only to this company associates holding subsidiary cash. For all these companies, you should not be a employee, proprietor, partner of the firms, legal consulting firm, cost auditor, company secretary, auditor. Then also you are not allowed. You and your relatives, both of them should not be here. And then if you are holding with your relatives 2% or more of the total voting power of the company, then also not allowed. And then then if you are a CEO or a director of a not-for-profit organization (NPO) and that NPO has 25% or more of its receipts from cash, company, its promoters, directors, holding, subsidiary, associate, it is having 25% of receipts from cash companies, and then it is holding 2% or more of the total voting power of the company. You are the CEO or director of a not-for-profit organization which gets 25% of its receipts from cash, and it is holding 2% or more of voting power of the company. If you are CEO or director of such a not-for-profit organization, then you are also not allowed to be appointed as an independent director. You or your relative should not be in this position in such not-for-profit organization. You should have appropriate skills, knowledge, etc. You should have. Then you should give a declaration, and you should give in the first meeting like that. You have to give the declaration of independence. Then you should follow the code for independent directors. You can get remuneration in the following manner. This is the provision related to the independent director. The term, you can have up to 5 consecutive years. And if you want to reappoint the independent director, you need special resolution and disclosure in board report. If you want to remove such a reappointed independent director, then also special resolution will be required. Independent director cannot hold office for more than 2 consecutive terms. Maximum 2 terms you can serve together. And then 3 years cooling period will be there after those 2 terms. You should not be associated with the company in any capacity, directly or indirectly, during the cooling period. And then some clarification issued by MCA. You can read that. Next, liabilities relating to the liability of independent director, in which cases the independent director will be liable. This retirement by rotation provision will not apply to independent directors. That point. Independent director versus nominee director, the differentiation they have given, they have explained it here. So that's all about the provision for independent director. They have given an exemption to the Section 8 company. This also you can read here. That's all about the provision for independent directors. Now, the next thing we are going to see is vacation of office of director, section number 167. If a director is appointed and he is getting disqualification, he is attracting disqualification after being appointed, he is not attending the meeting, or he is contravening section number 184, which relates to the disclosure of interest of an interested director. He is not disclosing the interest, he is disqualified by a court order, he is convicted by a court offense, 6 months or more he is going to jail, and then whether involving moral turpitude or not. And then kuch exceptions also, they have given some exceptions here. And then the director is removed following the Companies Act provisions, and then he is appointed as a director because he is, for example, holding as a director position in the holding company. Now when he is removed as a director from the holding company, then from our company also he will be removed. Then such other things also given here, punishment given. And then if all the directors are vacating the office due to the above mentioned reasons, central government will appoint the directors to manage the company till the next general meeting, where all the directors will be appointed again by the shareholders. So that's all about the vacation of office by a director provision. We have completed all the important topics in this chapter from where questions are coming. Now we can see section number 160, right of persons other than retiring directors to stand for the directorship. So if I am a retiring director, then in the general meeting in which I am retiring, in that meeting itself I can start a resolution and get the vote of the members and get reappointed. But if I am a normal person, I want to become a director, till now I have not been a director of a company. Now, how to become a director? You have to apply to the company. You will see the date of the general meeting. In the general meeting only the shareholders will vote and select the director. So the meeting will happen 14 days prior to the meeting. 14 days you have to send the notice prior to the meeting. 14 days notice prior to the meeting, you have to send it to the company. The company will see your application, and when you are going to become a director, like that you can do. And you are having one shareholder and you are a friend of that shareholder. The shareholder wants to propose you as a director. Then what he can do? The shareholder can send a written notice for the same 14 days. Same 14 days notice will apply here also. Then the next thing, whoever is standing for a director position, they have to deposit an amount. The amount will be 1 lakh or such higher amount as may be prescribed. So you can remember 1 lakh. Then who need not pay the deposit. For independent director, the requirement of deposit will not apply. And director recommended by the Nomination Remuneration Committee, then also this requirement of deposit will not apply. Director recommended by the Board of Directors, then also this requirement will not apply. This Board of Directors will recommend the director where there is no Nomination Remuneration Committee. But when you are having the Nomination and Remuneration Committee, they only will recommend the director. For independent director, and then the director recommended by NRC and board. For those people, this requirement of deposit will not apply. Then, after getting the notice, what the company should do? The company should inform the members. So, the proposed director should send the notice to the company. Company will inform the members. This is the process. Here what they will do at least 7 days before the general meeting. This informing will happen at least 7 days before the general meeting. For each of the members they have to provide the individual notice through their email or in writing they can give it. Then they will also place the notice on the website. After that, if they do the advertisement, so this is the normal requirement. They have to send the individual notice and they have to keep it in the website. But if they are advertising the candidature, the proposed director is going to stand for the directorship. That you have to give the advertisement not less than 7 days before the meeting. 7 days before the meeting, they have to give the advertisement in one vernacular newspaper and one English language English newspaper in that particular district. Which district? The district in which the registered office of the company is situated. Registered office, that district, vernacular newspaper and English language, at least once in both. If you do that kind of an advertisement, then this individual notice will not be required. After that, refund of the deposit. Now, if a director gets selected, then the 1 lakh deposit they paid earlier, that will be refunded to the director. And if they do not get selected, but they get more than 25 percentage of the votes, they are getting more than 25 percentage. More than 25 percentages of votes gained. Then also the deposit amount will be refunded. Now, if you do not win and you do not even get 25 percentage vote also, then your deposit will be forfeited. It will not be given to you. Then the next point is we saw some directors, right? Casual vacancy, alternate director, additional director, nominee director, and those directors, if you want to make them as a regular director, they are so currently special director. If you want to make them as a regular director, then also you have to follow this procedure. Section number 160, which is this section only. That's all about section number 160. Now we can see section number 162, appointment of directors to be voted individually. So here I will just tell you in short what is happening here. If you want to appoint one director, you have to pass one resolution. If you want to appoint two directors in the general meeting, you have to pass two separate resolutions, one resolution for each director. If you want to appoint two directors, it is not possible to pass a single resolution. That is what they are saying. But if you want to do that, there is one method. What is the method? You have to first put up a proposal. What is the proposal? The proposal is to elect two directors with one resolution. First, this proposal you have to put up, and if this gets the vote, and if it is voted in favor, and one more condition, no vote against it. The proposal is approved, and then everyone voted in favor, no vote is against it. Then what you can do? Then you can appoint two directors with one resolution. There is no problem. Normally this is not allowed, but earlier you put up a proposal for doing that, it is voted in favor, no vote is against it, then you can do this. Two director in one resolution, that is proper. Then if you did not get the proposal or you violated this particular section, then the resolution will be void. The resolution for appointing those directors will be void. So that is the section number 162. The next section we are going to see is section number 163, which is about the proportional representation. So now I will tell you what is happening here. For example, we can take one company. In that company, total 100 shares are there. In that, 60 shares are held by one group. Remaining 40 shares are held by another group. This group is the majority shareholder. This group is the minority shareholder. Now to pass a resolution to appoint a director, you need an ordinary resolution. This majority shareholder, they can pass the ordinary resolution, but this minority shareholder, they cannot pass the ordinary resolution. So because of that, all the directors in the board of directors, they will be appointed as per the wish of the majority shareholder. We will not even have a single director to represent the minority shareholder interest in the board of the directors. So what will happen? Their voices will be completely ignored and everything will happen according to the wish of the majority shareholder. But even if you see here, 40 shares they are having, 40 percentage. This is a very big percentage. They should have some kind of a representation in the board of directors. For their interest, they should have at least one or two directors. At least they should have that much amount of directors in the board. Only then their interest will be protected. For this only we are having the principle of proportionate representation. Here, the minimum two-thirds of the directors. minimum two-thirds of the total number of directors will be appointed as per the proportional representation. This requirement should be there in the articles of association of the company. The articles should say that minimum two-thirds of the directors will be appointed as per the proportional representation. This requirement should be given in the articles. After that only you can implement this section. This much directors will be appointed as per the proportional representation. What will happen? This we can do it in various methods. Like we can have a single transferable vote. Like every person will have vote and then one quota will be fixed. Minimum 26 votes or 30 votes. This will be the quota. If this much votes some person gets, then he will be appointed as a director. Like that we can have one system, or cumulative voting system we can follow, or any other transparent system we can follow. In that system, this proportionate representation should be done. That is the only requirement. And if a director who is appointed through the proportionate representation mechanism and he dies or he goes away, he resigns or something happens to him, he can no longer function as a director, a casual vacancy will arise. This casual vacancy can be filled by the board of directors, but after filling in the immediately next general meeting, they have to regularize the particular appointment from the shareholder. In the general meeting this should happen. So this is the entire provision of proportionate representation. The same thing is given here, you can read here. One more point is missed, that is the overriding effect. So this particular provision will have overriding effect over all the other provisions of the Companies Act. This is the main notwithstanding provision. Even if some other provision has some other against some requirement against this section, then this section only will win. This section prevails. That's all about this section number 163. The next section is about maintaining a data bank for the independent directors. So a data bank will be maintained in that all the names of the persons who are eligible to be appointed as the independent directors, their names will be there, and the company can choose the independent director from that list. Before choosing the director, they have to do the due diligence. They are having the list, but in that, before selecting a director, they have to check the background of the director. That is the responsibility of the company. This data bank will be maintained by the Indian Institute of Corporate Affairs. So that will be maintaining the data bank. And if you want to enroll into the data bank, your name should be included in the list of the independent director. Then you can make an application. You have to make an application if you want to get appointed as an independent director. Your name will be included. When you are making the application, you have to specify you are making the application for 1 year. This means that your name will be included in the data bank for 1 year only. After that, it will be removed. If you want to make an application for 5 years, you can do it, or lifetime also you can do it. For your entire lifetime, your name will be included in the data bank. So, if you are choosing 1 year or 5 years, then after this period, within 30 days from the expiry of the period, you have to do the renewal of the application. Only then your name will be continually present in the data bank. So, if you are doing a lifetime application, then no need to do the renewal and all. Here if you see, when you are filing the application, there is a requirement for the test. So we can add one more page so that I will be able to write here. For independent director, we are having two methods. If you want to become an independent director, we are having two methods. Method 1 is through the exam, OPSAT, online proficiency self-assessment test. Second method is through experience. If you are having the required experience, like you are a CA, CMA, CS in practice for 10 years, you are having 10 years of experience, then you can have this experience, you can be enrolled as an independent director. No need to write the test and all. So now what will be the process, that I will tell you. When you make the application, your name will be included, and after that you are having the time. Within 2 years, you have to clear the test. If you do not clear, your name will be removed. After removing, is there any way to bring your name again into the list? You can make an application for restoration. In the restoration process, again they will add your name into the data bank, but it will be in a separate category. Separate category where restored will be written, and under that category only your name will be restored. After that, within 1 year, you have to pass the test. If you do not pass the test within that 1 year also, then again you have to do the fresh application, and you will again get 2 years. You have to clear the test. Otherwise, again it will be removed. Again you can do the restoration. Then 1 year you will get. If you do not clear in this final 1 year, then again you have to apply afresh. That is the thing. And when you are exempted from the requirement of test, no need to do any test and all. Now, I hope you understood the process. Now we can see. Now here one more thing. Here if you clear the test, then no problem. For the period for which you made the application, 1 year or 5 year or lifetime, your name will be there in the list. There is no problem. Here I told you that if you are having experience, then no need to clear the test. Here not only CS, EMS, CS, we are also having other professions or other people who are exempted from the test requirement. That also we can see here. Here, you are having 3 years of experience as a director or KMP of a listed public company or an unlisted public company having 10 crore paid up share capital or a body corporate in another country. A body corporate in another country, you are a director or key managerial personnel in that particular body corporate. This country is a member state of the Financial Action Task Force Committee or the Security Commission, International Organization of Security Commission. That country is a member in these commissions, in these committees. After that, in that country, your body corporate is there. In that body corporate, you are a director or KMP. Then you have served for minimum 3 years. That should be there. In all these positions, you have served for minimum 3 years. 3 years you have to served in the position. Then body corporate incorporated outside India having a paid up share capital of $2 million or more. Then such a big body corporate you have been a director or KMP. Then also you are exempted from the test. You are a director or KMP in a statutory corporation set up under an act of parliament or state legislature for minimum 3 years. Then also no need to write the test. In the pay scale of a director or equivalent or above in any ministry department, and you're having the experience in commerce, corporate affairs, and you are experienced in the government company or statutory corporation related affairs also. You are having the pay scale. You are not a director or KMP, but your salary, which is equivalent to the director. Your salary, you are getting the same amount of salary like a director in a government company or a ministry, like ministry or department, and you're having the experience in these affairs, then also no need to write the test. After that, you're in the pay scale of a chief general manager in SEBI, IRDA, PFRDA, and you're having experience in corporate laws, securities laws, economic laws, then also no need to write the test. And one more thing, these positions in two or more companies, it will be counted only once. For example, if you want to get the 3 years experience, you have to be in one company for 3 years. You can also think like that. I am in three companies. I am having the position in three companies for 1 year. Then also it will be counted as 3 years. Like that you may think. This is only not allowed. When you are having the position in three company, you are working in all three companies for 2 years only, then it will be counted only 2 years. Even if you are in three companies, the position 2 years only you have worked, so 2 years only will be counted. Then here only I told you, in practice as a chartered accountant, cost accountant, company secretary, having 10 years of experience. Here you have to include the advocate of a court also. These people having 10 years of experience, they also no need to write the test. Next, I told you that you did not write the test and pass the test within the 2 years. So your name removed. Then you can apply for the restoration of name. It will be in a separate restored category. Within 1 year from that, you have to pass the exam again. If you fail to pass, you have to apply afresh. That thing is there. Then due diligence. The due diligence means after selecting the name from the list, the director, the company should verify the background of the director. After that only they can appoint as an independent director. The appointment will be approved by the company in the general meeting, and in the general meeting notice you have to give an explanatory statement. In that statement you have to tell the justification why you appointed this person as the independent director. You have to tell the reasons. So manner, procedure, everything will be defined by the central government. So that also there. That's all about this particular data bank section. The main section is independent director section only. This is a what we can say supplementary section to the main independent director section. How the administrative part will be handled for the independent directors. That is specified in this section 150. And one more point before starting the next section, here one point to state, that is the submission of declaration of compliance to the board. You have to give a declaration of compliance that you properly followed all the rules and regulations. That sub rule 1 and sub rule 2 you have to follow properly. This declaration, when you have to submit, when you're submitting another declaration under subsection 7 of section 149, for that independent director section, we are having one declaration that should be given by the independent director. Along with that, you have to give this declaration also of sub rule 1 and sub rule 2. Now we can see the next section. This is the next topic, which is about the duties of directors. What are all the duties of directors? We already know what are all the duties. They have to act as per the articles of association. They have to act in good faith for the best interest of the company. They have to try to bring profit to the company. They have to act with due and reasonable care. They should exercise their diligence. They should be careful. They should use their independent judgment. They should not involve in a situation where there will be a conflict of interest with the company. So the director should not involve him in such a situation. What situation? In that situation, two decisions should be taken. They are having two options. First option is to get profit for the company. Second option is to get a personal gain. This will be called as a conflict of interest. They have to choose between two things. One is the profit for the company, that is the best interest of the company. Second one is personal gain, personal interest of the director. There should not be any conflict between these two. There should not be any situation where the director is in a position to choose between these two. Like that, it should not happen. Then they should not achieve any undue gain or advantage by using the company. They should not assign the office, and if they do like that, it will be void. Assignment means my work. I am as a director in this particular company. I am in the position of the director. After me, this person will become the director. Like that, you cannot do the assignment. Or I am assigning this position to this person. Like I am transferring it. From now on, I will not be the director. This person will be the director. Like that, you cannot assign the position. You have to get the shareholder approval. For that, that separate approval should be followed. You cannot directly assign your particular office. Then you are having some other duties also. You have to file the documents wherever RBI, SEBI, ROC, everywhere you have to file the documents, convene the general meetings, attend the board meetings. Then you have to disclose the interest. As per the disclosure of interest by a director, as per that section, you have to disclose your interest. Like in what companies you are having the shares, in what firms you are a partner, in what body corporate you are having the interest. Everything you have to disclose as per that particular section. You are having the detailed provision in the chapter of meeting of board and its powers. We will be seeing it in the third chapter, meeting of board and its powers. They have to approve the financial statements. They have to prepare the board report, approve the board report, attach the board report to the financial statements. Then, in that board report, director responsibility statement should also be there. They have to appoint the first auditors. Everything should be done by the directors. These are all the duties of the directors. The next section is section number 168, where we have to talk about the resignation of the director. When a director can resign by himself, what is the procedure to do that? So first, a notice should be sent to the company by the director. We can add one page here. So the director who is going to resign, he has to send a notice to the company. Notice should be sent. What the company should do, they have to take note of the notice. Here if you see, they have to send the notice of resignation by the director to the company. The board will take note of the receipt of notice. The board of directors. Then company will send this fact to the registrar within 30 days in form DIR 12. Now company will send to the ROC in form DIR 12 within 30 days. This is the work of the company. First, notice from the director to the company. Then company will take note. After that, they will send to ROC the resignation in form DIR 12 within 30 days. Next point. Facts of such resignation should be given in the report of the directors in immediately next general meeting. The next general meeting will be there, right? In that, this fact that this director resigned, that should be there in the report. That should be there in the board report. After that, what will happen? The director will forward the copy of resignation with reasons to registrar within 30 days from the date of resignation in form DIR 11 with fees. Then what will happen? The director who resigned, they have to send one form DIR 11 that they are doing the resignation. Along with that, they have to send the reasons why they are doing the resignation. This should be sent to the ROC within 30 days of resignation. So this is the process. First, the director will send the notice to the company. Company will take note. Then within 30 days, it will send it to ROC in DIR 12 form. After that, director should finally send one DIR 11 form. In that, resignation should be written, and then the reasons for resignation should also be there. Within 30 days of resignation, they have to send it to the ROC. Then, in the next general meeting, the fact of this resignation should be noted in the board's report. So that's all about resignation of director. Then some more points we are having that also we can see in case of a foreign director. So a normal resident director in India, they will send the DIR 11 form themselves. But if it is a foreign director, what will happen? The foreign director, they can authorize a CA, they can authorize a CA, CMA, CS or other resident director. In that company, there will be other resident director, right? They can authorize them to fill the form DIR 1, DIR 11. To send the form DIR 11, they can, foreign director will authorize these people and these people will send the DIR 11. That is one more point. The next thing. Now, one more point here, what they are saying is that here, if all the directors resign, when one director is resigning, there is no problem. When the company is taking note and then they are sending the DAR 12 form, in that one sign should be there of the director. One director's signature should be there as an authorized signatory for the company. One director who's still a director, a normal director, their sign should be there as an authorized signatory for the company. But when all the directors are resigning, there will be no one to sign as the authorized signatory. In that case, what will happen? The ROC can give permission to one director alone who is resigning to give the sign as an authorized signatory. The ROC will give permission to one director, even though he is not a director now, he can sign the DIR 12 form as an authorized signatory for the company. And one more thing, if all the directors resign, then what will happen? Who will appoint the next director? The promoter or the central government will appoint the required number of directors. Then that number of directors, they will be working as the director till the next general meeting. In the next general meeting, the shareholders, they will appoint the directors. If all the directors resign, there are no directors now, then the promoter or central government, they will appoint the minimum number of directors and they will hold the office till the next general meeting. And one more thing, effective date of resignation. When you are resigning, what will be the effective date? The date on which notice is received by the company or the date in the notice, whichever is later. So, notice, receipt date. Date on which company receives the notice. And then, date mentioned in the notice. Whichever is later. So this is the thing. For example, here we can take 1st August, the company receives the notice. And in the notice they are telling that from 15 August, the director is resigning. Then 15 August will be the date of the effective resignation. But the director sent the letter, the director says that from 30 July itself, I am going to resign. This is the thing given in the date of notice. But the notice itself received by the company on 5 August. Then what will happen? From 5 August only the director will be relieved. This means that from 30th July till 5 August, the director will be liable for all the actions. And one more thing, after the director resigns, will there be any discharge of liability? Will the director be absolved of all the liabilities? No, that is not going to happen. For the period in which that person is a director in the company, all the actions in that period, the director will also be responsible. Even though he is not a director currently, for the period in which he was a director, for those actions, the director will also remain responsible. That they have given. The next section is section number 169, which is about the removal of the directors. The directors can be removed by the tribunal or by the shareholders. By the tribunal, when the tribunal will remove, they are having the power under section 242. This 241, 242, these are all the sections under the chapter Prevention of Oppression and Mismanagement. Now, first shareholders will make an application to the tribunal. What application? That the management is not working properly, they are hiding something, they are doing some fraudulent activity, like they are oppressing me, they are not giving the proper rights, like that. The shareholder will make the application under section 241. After that, tribunal will review the case and they can remove the director. Their power is given under 242. This is one type. The second type is that shareholder, they can pass ordinary resolution or special resolution and they can remove the director. Normally, ordinary resolution is enough. For appointing a director, for removing a director, ordinary resolution is enough. But in the case of a reappointed independent director, for example, independent director is there, one term completed, and then you are reappointing him for a second term. Then in the second term, if you want to remove him, then you have to pass the special resolution. Their special resolution will be required. And in some cases, you cannot even remove the director. In what cases? If the director is appointed by the tribunal under section 242. What is the section 242? It is under the chapter of prevention of oppression and mismanagement. Here, the tribunal will pass order to regulate the company. What they will do to regulate the company? They will set aside some agreement, they will remove some director, they will pass some instruction. This you have to follow when you're handling the company, when you're managing the company. This you have to follow, like that. They will do the instruction, they will do everything to regulate the company. In that, they can appoint some director also, they can appoint some director in the company. This director will be a part of the board of directors and they will periodically report to the tribunal whether the company is working properly or not. Like that, the director will be appointed by the tribunal and this director the shareholders cannot remove. Then, one more thing. If a director is appointed by proportionate representation, then also that director you cannot remove. Proportionate representation, that section itself is there to protect the minority shareholders. Then you cannot remove such a director. Then, when you are removing a director, you have to give a reasonable opportunity of being heard. And one more point, before removing a director, before conducting that meeting itself, you have to give a special notice that you are going to propose to remove a director. That resolution is going to be passed. For that, you have to give a special notice. That notice should be signed by members holding not less than 1% of total voting power. Members having such shares, they are holding 1% of total voting power. They have to sign. Otherwise, member holding shares on which at least 5 lakh has been paid in aggregate, they are having some shares. On that shares, face value, premium, everything together, they have paid 5 lakh rupees. All the amount together, they have paid 5 lakh rupees on the shares. Then, such members also, if they sign the special notice, they can put up the resolution. The company will send a copy to the director. So, this notice will be sent by the members to the company. They have to send send the notice to the company. What is the time period? At least 14 days before the meeting, but not later than 3 months before the meeting. So, meeting is happening here. So, this is the 14 days gap. You have to send it before the 14 days. But 3 months you are having. Before 3 months, you should not send it. It should not be very early, it should not be very short notice. It should be appropriately. Not earlier than 3 months, but not later than 14 days. Like that, 14 days before the meeting and not 3 months earlier before the meeting. Then action by the company. The members will sign the special notice, they will send to the company. Company will forward it to the director. And the director, they can give a written reply. For this particular resolution, they can give a reply. Like, I did this for the good of the company only, I did not do any misconduct. Like that, the director can give a reply. That reply, it will be sent to all the shareholders. Then, if you are not able to send the reply, the director gave the reply, but because of lack of time, you did not have proper time to circulate the reply to all the shareholders. Then you have to give the opportunity for the director to read out the reply. They should be able to read out the reply in the general meeting. Then, this director reply, they have to mandatorily read in the general meeting. But one exception is there. What is the exception? If the tribunal is satisfied that the director is trying to secure needless publicity, the reply of the director is such that there is no proper thing in that. It is just for the needless publicity. Then, if you convince the tribunal like that, if tribunal says like that, then the director reply, no need to read it in the general meeting. Normally, the director reply have to read it in the general meeting. If you did not send it as a separate notice to each of the shareholders. Then, the vacancy resulting from this, it can be appointed by another director in the same meeting. Like if you are removing a director successfully, after that there will be casual vacancy. This casual vacancy can be appointed by the members. In the general meeting only they are removing him. In the same meeting you can reappoint another person to fill that casual vacancy. And if they did not fill it in the same vacancy, then the board of directors can appoint it. But when the board of directors are filling that particular casual vacancy, they cannot appoint the same person who was removed. The person who was removed, he should be removed only. You cannot appoint the same person as casual vacancy. Then, if you are appointing such a person for the casual vacancy, then he will be holding office till the end of the original period. The director, he was originally appointed for 4 years. Then, for that time period, this new director who is appointed for the casual vacancy, he will also be there. Then you can provide the compensation for loss of office, everything you can pay to them. But you have to keep in mind section number 202. You can pay the compensation for loss of office, but you have to keep section 202 in mind. They are having the limits in section 202. Maximum how much you can pay as a compensation for loss of office. Then we are having one more point. I told you that the tribunal also can remove a director, and if tribunal removes a director, for that director you cannot pay the compensation for loss of office. This point we will see again in the prevention of oppression and mismanagement chapter. For the director removed by the tribunal, you cannot pay the compensation for loss of office, and then you cannot appoint him again for a period of 5 years again. From the date in which he was removed by the tribunal, you have to wait for 5 years before appointing him again. If you want to appoint the director within the 5 years itself, then get the permission of the tribunal. The next section is section number 170, where register of directors and key managerial personnel and their shareholding should be there. Who are all the persons who are directors in the company, who are KMP in the company, what is their shareholding, in what are all the companies they are holding the shares, in the company or its holding subsidiary or subsidiary of its holding or the associate companies. So the directors or KMP, they are holding the shares. In which companies they are holding the shares? The main company or the holding company or the subsidiary company to the main company or associate company or subsidiary of such a holding company, which is called as a sister concern. So here when you see in these companies, what is the shares held by the director or KMP? That should be given in the register. That should be written in the register. In that register, all these details should be there. Name, surname, father name, date of birth, residential address, nationality, occupation. The entire details should be there. And the details of the securities held by them. Number of securities, nominal value of securities, date of acquisition, date of disposal, cumulative balance, mode of acquisition, everything should be there. Then they have to file Form DIR 12 within 30 days of appointment of the director and within 30 days of any change taking place in this particular register. Like if you are appointing the director, then also you have to file DIR 12. If there is any change in the designation, you are changing the position, then also you have to file the DIR 12. Then the next thing, members, the shareholders can inspect the register. They can see the register, they can examine the register. They can do it during business hours and then they can take the copies also. The copies should be provided by the company within 30 days free of cost. The register will be open for inspection in the general meeting also. And if the company does not allow you to view the register, then you can make an application to the registrar and the registrar will order immediate inspection and supply of the copies. The registrar will order them to immediately provide the copies. That is the section 171 members right to inspect. Then punishment section also we are having, that also you can read by yourself. No specific penalty. If under any section there is a violation but no specific penalty is given, then this penalty will apply. The officer in default, he will have 50,000 rupees penalty and company also will have 50,000 rupees penalty. Continuing failure, 500 rupees for each day. Maximum 3 lakh rupees for company, 1 lakh rupee for officer in default. So that's all about this particular section 172. Now we have completed the entire directors chapter. Now, after doing this, if you learned from this video, if you have understood this video, please like this video, share this to your friends and subscribe to the YouTube channel. Your friends also will get benefit from this video. And the notes which I am using here, it will be there in the website. You can download it from there. All the best for your exams.